Thank you, Your Honor.
Justice Leonen.
Good afternoon, Congressman.
Yes, sir.
Am I right to assume that you must have imagined that while you were defending this bill as principal sponsor in the floor of the House of Representatives, that you would one day appear before us on the same topic?
Yes, Your Honor. From the very start of our debates, we anticipated that the bill, if enacted into law, would be challenged before the Supreme Court.
So would it be presumptuous on our part to say that it was not only you, but the other sponsors of this bill, as well as those who were debating against the propositions, that knew that someday we would be here in the Supreme Court?
Definitely, Your Honor, that was our expectation. And that's why even during the debates, we extensively discussed constitutional issues.
May I know what was the voting of the House of Representatives on second reading on the bill?
I think, if I remember right, on second voting, the bill was approved by a margin of 9 votes.
By a margin of 9 votes.
9 votes.
And on third reading, was the vote the same?
No, Your Honor. On third reading, it was a wider margin. I think it's more than 50 or so.
50 votes. And may I know what changed between the second reading and the third reading?
Well, Your Honor, it was a realization that, one, there is really a need for the passage of the reproductive health law on the part of those who were still ambivalent. And also, the bill was certified by the President as urgent, and most probably that gave a push for the wider margin in favor of the bill. But I would like to underscore that the certification of the President came after the RH advocates won on second reading.
So I am also, we can be also right to assume that apart from your reading of the Constitution, the representatives in the House of Representatives were also considering other factors, such as, for instance, your political futures, that many of you were going to go for re-election for their various districts, as well as a matter of fact, the media, who would project each argument that was made on the floor.
Your Honor, during the debates, we circulated the consistent survey that the electorate would vote for candidates who have an agenda on family planning and reproductive health, and that 75% of the voters would vote for candidates who are willing to spend public money for contraceptive use and who are willing to have sexuality education enforced by government. So our colleagues were fully aware of the sentiments of our people, and we coupled this survey with various surveys nationwide, region-wide, and district-wide, which would authenticate that the people are really clamoring for the passage of the RH law, including its salient provisions.
So, unlike this specific forum that we have today in the Supreme Court, there were about 200 plus of the members of the House of Representatives discussing with each other, forming political coalitions on this bill, debating with each other almost on a daily basis during the time that it was in second reading. And the back of your minds was not only the Constitution, but also what you felt were going to be the views of your constituents. Am I correct in this?
Yes, Your Honor. And we took the position that our constituents would endorse the approval of the bill. Many of us went to our districts and made surveys, and we felt the pulse of the people, majority of whom are Catholics, and they resoundingly endorsed the enactment of this bill. So we were consistent with the wishes of our constituents.
Yet, in our hands lies the ability to declare this entire law as null and void ab initio, and therefore the effect, rightly or wrongly, just the effect, counsel, would be to erase what had happened. Is that not correct?
Well, we hope it will not happen, but that the Supreme Court has the power to nullify this law, and in the process, we feel that the claimor of the constituents, the decision of the two political departments would be overruled by the court.
But that power is lodged on us by the constitutional order on the basis of our ability to be able to find judicially determinable standards or principles or value embedded in the Constitution. Is that not correct?
Yes, correct. That's how the power of judicial review is circumscribed.
Yes, and what I know is that our power is circumscribed only by us, and in many of our jurisprudence we have said that that principle or value must be very clearly stated and very convincingly violated, at least at bar, when a case is presented before us. Am I not correct?
Yes, Your Honor. There must be a very clear case of a violation of the fundamental law in order to declare a statute unconstitutional.
By the way, has this law been implemented?
Well, there was this, before the implementation started, there was the status quo ante order issued by the court, which has been extended indefinitely, and the law has not been implemented.
So, as a matter of fact, we will not be able to see yet whether the words in the Constitution, the words in the statute, will be interpreted this way or that way by the administration, for instance, the FDA or the Department of Health, because it has not yet been implemented. Is that not correct?
That's correct, Your Honor.
In your experience, because I know you, Congressman Lagman, I know your history as a lawyer, at the same time as a member of Congress, as a legislator, in fact as a leader of the legislature, in fact also a minority leader. In your experience, have there been instances when Congress has perfectly came out with words such that there can be no other interpretation except the interpretation that you wanted it to be? Or are words in statutes, even the Constitution, inherently there are differing interpretations of some of the words in statutes?
Well, generally, statutes would convey the intention of the legislature in the very phraseology of the law. And we feel, Your Honor, that in this particular statute, the reproductive health law, we have endeavored and succeeded to have the phraseology of the law consistent with the intention of the legislators of Congress.
As a matter of fact, the default standing of this court must be to allow you to have that discretion. Is that not correct?
Yes, Your Honor.
And in fact, we cannot interfere with that discretion unless there is, in the words of the Constitution, grave abuse of discretion. And I think it's a very redundant term if not looked in a technical sense. Not only must it be abuse of discretion, it must also be grave abuse of discretion. Counsel, may I know what your thinking is on this particular point?
Well, as far as the requirement of grave abuse of discretion, we submit that the Congress did not commit any grave abuse of discretion. And we have fully ventilated the issues, and we have resolved the conflict between the between the proponents and the critics in a very civil and procedural and substantive manner, that we have enacted a law which would address both the concerns of the proponents as well as the reservations of the critics of the law.
And that discretion also applies to the evil that you want to prevent as Congress, and of course, when the President approves your bill into law, the evil as well as the means to address that evil. So for instance, Counsel, when you decided that to address the maternal deaths, the numbers of maternal deaths existing out there, that discretion is entirely yours and is not within the province of the judiciary. Am I correct to assume that?
Well, yes, Your Honor, we claim that discretion is vested on the legislature.
Therefore, when you gave priority to maternal deaths, rather than, for instance, cholera and malaria, assuming for the sake of argument that there is still no law on malaria and cholera, assuming only for the sake of argument, that discretion cannot be touched by the judiciary. Is that not correct?
Yes, Your Honor, because that goes into the wisdom of the statute, and the wisdom of statute is not subject to judicial review.
And when you said a while ago, if I'm not mistaken, that 1/3 of all maternal deaths can be prevented by mere contraception, that finding also is not within the province of the judiciary, but we should allow Congress, acting as a whole, this by the House of Representatives and also by the Senate, and with the President, with all his advisors, to determine that that is in fact a fair and, shall we say, a reasonable determination on your part.
Yes, Your Honor, because we receive evidence and facts before we made that determination.
Absent clear, grave abuse of discretion, which means that it has no basis in science whatsoever, no evidence, no science to support it, then are you saying that it is binding on this court, that is a good way to prevent maternal deaths? That is, by the use of contraception, 1/3 of all maternal deaths can be reduced.
Well, the determination, I submit, Your Honor, that the reproductive health law would prevent 1/3 incidence of maternal health with medically safe, legal, effective, and non-abortive patient reproductive health and family planning services and products would be the domain of the legislature, and also as approved by the executive. So the two political departments wherein representatives of the people are present have made that determination already.
Again, Counsel, I know from your experience being with Congress and as a practicing lawyer, perhaps also addressing the many needs of the administration and this court in terms of budget hearings and all of that. Why is it that it is Congress that should have that ability and not this court?
Well, Your Honor, the Congress has the wherewithal of determining these particular priorities with respect to which should be legislated and budgeted. Because this also involves the budget, and the power of the purse belongs to Congress.
And your determination of the facts is not as strict as the determination of facts in court. Is that not correct?
Yes, Your Honor.
Let us go to another topic, and this is the right to life, which is also your topic, Counsel. You mentioned the existence of Article 2, Section 12, and that I think that it reads, it shall equally protect the life of the mother and the unborn from conception. Is that not correct?
That's correct, Your Honor.
Now, of course, there are a lot of imponderables in that statement. One, of course, is what is meant by equally protect. Counsel, would you know of this term therapeutic abortion?
Yes, Your Honor.
And in cases of therapeutic abortion, there are instances when it is the implanted fetus that needs to be let go, or it is the fertilized ovum, if it is blighted, that should be let go. Is that not correct?
Yes, Your Honor.
But at this point, does this law actually compel us now, with the words in the statute and with the petitions that were filed with us, for us to actually determine when conception actually is?
As we have submitted earlier, Your Honor, it is not necessary for this Honorable Court to adjudicate that particular question in order to resolve the issues of constitutionality raised by the petitioners.
You mentioned a while ago that the law defines abortifacient, but it does not define abortion. Why is that so, Counsel?
Well, Your Honor, because the law is very specific already on having anti-abortion policy, and that abortion has a well-defined medical and legal meaning, which is the expulsion of the embryo or fetus from the mother's womb before it becomes viable. That is a standard definition, Your Honor. And there is no need to reiterate such definition.
And when the constitutional commissioners wrote that phrase, equally protect the life of the mother and the unborn from conception, in fact, when the people ratified the Constitution, wouldn't you say that it was also aware that there are instances when these dilemmas would have to come forward and be decided upon by law and, in fact, by a court of law at some point?
Yes, Your Honor.
Why is it that we cannot decide it now when we want to? Counsel?
Well, Your Honor, because the reproductive health law as enacted is well within the confines of the Constitution, and we have not violated any particular provision of the Constitution, even that provision on the equal protection, that the state shall equally protect the life of the mother and the unborn from conception. We have addressed that problem, and we are consistent with that provision. We uphold that provision, and definitely the reproductive health law has not infringed on any particular provision of the Constitution. That's why we are beseeching the Honorable Court that like the political departments which have clearly approved this measure, like the Filipino public, majority of whom are Catholics, who have clamored for the enactment of this law, we hope that the Supreme Court would also sustain the constitutionality of this law.
And we cannot rule upon it unless it is a case itself, an actual case, because the judicial temperament is supposed to be one which does not only provide advice, because we cannot provide advisory opinions, we cannot decide on theory, but we must have the actual facts before us in order to frame the issues as well as the modalities of interpretation of both the statute and the Constitution that we have. Isn't that correct, Counsel?
Yes, Your Honor.
Yes. Let's go to the right to continue with the right to life. Would you agree with me that the right to life is not only the right to existence, but also to a certain quality of life in our present Constitution?
Yes, Your Honor, but when we say quality of life, we're not anymore talking about the unborn. We are talking of the millions, the multitude of those who are already born and living.
But there are relationships, is it not, Counsel, for if there are too many children to a couple or to a person who might be a single parent, but that single parent may not have the wherewithal to provide for all of them, then certainly there are effects of his material existence on the quality of life of the children. Is that not correct?
Yes, Your Honor.
And the government cannot simply stand idly by watching that happen, and therefore government must provide for a situation where that can be prevented, or if not, if it actually happens, that the children are provided for and the families are able to provide a good quality of life. Is that not correct?
Yes, Your Honor. That is why one of the compelling reasons for the enactment of this law is that we will have to address this ballooning population, which impacts adversely on all major human development indicators like education, health, food security, mass housing, employment, and even the environment.
Thus, Article 2, Section 12 must be taken in an entire context of the entire Constitution. Is that not correct?
Yes, Your Honor.
Which means Section 11, which provides for human dignity, Section 10, Article 2, which provides for social justice in all phases of life, Section 14, which provides for fundamental equalities between men and women, Section 9, which provides for government inducing rising standards of living, Section 15, which says the right to health, and Section 17, one of my personal favorites, total human liberation. So, it is not only the existence that is in question, but what kind of existence under the Constitution. Is that not correct?
Yes, Your Honor.
Yes. And in this regard, it is the Congress and the President as political agencies that will decide how government is going to provide for it rather than this court. Is that not correct?
That's correct, Your Honor.
All we can say would be whether the decisions on programs, and in fact the law as it is applied, violates a fundamental principle in the Constitution. Is that not correct?
That's correct, Your Honor.
And we have to be careful about it because we trump the political departments whenever we declare that a certain law or any of its provisions are unconstitutional. Is that not correct?
That's correct, Your Honor.
Would you say, Counsel, that each and every provision in this law has been fought for, bargained for, compromised during the political deliberations?
Yes, Your Honor, and all of them are consistent with the Constitution.
Yes. Just for purposes of the record, and perhaps you can also cover it in the memorandum, but if you know, during the bicameral, how many points of contentions were there between the Senate and the House?
Well, generally, there was unanimity between the House and the Senate panel on major provisions like the universal access to reproductive health information, care services, and commodities, provided these are not abortifacient and would not prevent the implantation of the fertilized ovum in the woman's womb. There was unanimity on reproductive health education. There was unanimity on the Philippine National Drug Formulary, except that there should be no certification of approval for drugs or devices which are considered to be abortifacient or not medically safe. There was also unanimity in on the question of the Department of Health being the lead agency in the implementation of the law. There were certain problems with respect to the role of the LGUs in the national government. But this was resolved in favor of a joint responsibility in the implementation of the law, with the national government being mandated to give budgetary and financial assistance to local government units in the implementation of the law.
Thank you, Counsel. Let's go to another point, and this is part of your presentation and argument, and this is on the legislative intent. Would we be correct in saying that the legislative intent of Congress is not determined by what the principal sponsors say in public, but how the law is actually worded?
Yes, Your Honor.
And by the law being worded, it is not by isolating phrases in the law, but taking it in its overall context. Is that not right?
Yes, Your Honor. And that is a general prescription with respect to the construction of the statutes, that they should be read as a whole and not by individual provisions.
Let us go to Section 9, for instance, something which was discussed a while ago. And the provision there has this portion relating to shall include hormonal contraceptives, intrauterine devices, injectables. So the National Drug Formulary, taking that phrase alone, actually that provision seems to say that it includes already hormonal contraceptives, intrauterine devices, injectables. However, if we continue on and read the entire sentence, it does say and other safe, legal, non-abortifacient, and effective family planning products and supplies. There is the words there, the words there, safe, legal, non-abortifacient. Does that only qualify the word other, or does that also qualify hormonal contraceptives, intrauterine devices, and injectables?
The antecedent would include hormonal contraceptives, intrauterine devices, injectables, because all of them should be safe, legal, non-abortifacient, and effective as determined by the appropriate government administrative agency, which is the Food and Drug Administration.
So because it's in one entire statement, therefore redondo, singula, singulis will apply, which means that we apply all the adjectives to all the nouns that come before it. Is that not correct?
That's correct, Your Honor.
So therefore, we can say that there are hormonal contraceptives which may not be allowed by the FDA.
Yes, Your Honor.
But there are hormonal contraceptives which may be allowed.
Yes, Your Honor.
Did Congress actually say that all hormonal contraceptives are therefore safe and therefore allowed?
We did not say that, Your Honor.
Okay.
We did not have the competence to say that. That's why we devolved to the Food and Drug Administration the authority to make such determination.
Again, on intent, Counsel, Section 23, subparagraph A, number 1, where the word incorrect exists. And, looking at the phrase, provide incorrect information scares all of us. Provides incorrect information because it seems to imply that the government has a monopoly of correct information. However, first let me ask you this question. When a doctor prescribes to a diabetic soft drinks, is it something that should be frowned upon, proscribed, and even punished?
Yes, Your Honor.
Because
it would be deleterious to the health of the patient.
As a matter of fact, when a doctor prescribes or says that it is all right to smoke to a person who has already lung cancer or throat cancer, that too is something which is mischievous, should be proscribed. In fact, given that it is very negligent, it should be punished with penalties as well as civil liabilities. Is that not correct?
Yes, Your Honor. That is in the nature of an incorrect information.
Can we take letter A? Any healthcare service provider, whether public or private. It does not say anybody. It just simply says healthcare service provider that provides incorrect information. These are the people that are going to be punished. Is that not correct?
Yes, Your Honor. It's a definite class of people. These are the service providers.
In other words, we are saying that we are not only looking at the particular provision, the particular phrase isolated, but we should look at the entire context of the entire law. Is that not correct?
Yes, Your Honor.
This should be the attitude of our courts. Is that not correct?
Yes, Your Honor.
Or should we presume that there is something sinister or unconstitutional about these provisions?
Being sinister or unconstitutional is never presumed, Your Honor. The
Yes.
opposite is presumed.
Okay. Let me go to one other point, and perhaps you might be the best person to address this. You were asked a while ago whether there was a preferential treatment in this law for the poor. Is there a preferential treatment for the poor in this law?
Well, Your Honor, the intention of the law is to make beneficiaries of this law, voluntary beneficiaries, more from the ranks of the poor and the underprivileged, because they are the ones who do not have access to reproductive health information, services and supplies. And moreover, they are the ones who need such information and supplies, because with respect to those who are well off, they have their own means of accessing contraceptives and reproductive health information. And the data would show, Your Honor, that it is in the lowest quintile, where there are so many children. The average is still about 5.5 per woman, which is the average total fertility rate 40 years ago. And that's why that is a compelling reason which the Congress should be able to address and remedy.
At the risk of repetition, because you did say this during your oral arguments, just so I am also clear about it, access does not mean use. Is that not correct? Access does not mean use.
Well, we can start from the proposition that availability is not access.
Meaning to say
and access may not be equivalent to use.
that the crux of this law is to provide the data, the information, the technology, make the information available. But is it true that this law compels the poor to use a condom, compels them to use an IUD, a copper IUD, compels them to use a dangerous hormonal contraceptive?
No, Your Honor. The general central to the law is freedom of informed choice, and I could point out now or in the memorandum the different provisions which would provide for informed choice and respect the choice of couples and women.
Perhaps in the memoranda that the councils are going to submit, because I surmise that even the petitioners are going to have their own interpretation of several portions of this law. Maybe a last series of questions. And I do this only because I know that you have been a human rights advocate, and your family has suffered a lot in terms of human rights violations, the disappeared as well as an assassination of a brother. And if I may ask you this, genocide was mentioned in terms of this particular law, that this particular law was targeting the births of the poor and reducing them because they are poor. Do you agree that this is a law on genocide?
No, Your Honor. That is an aberration of a conclusion or a appreciation of the law.
As a matter of fact, genocide as properly defined in specific treaties must be addressed particularly at a particular race, ethnicity, or religion. Is that not correct?
That's correct, Your Honor.
And that is for the purpose of actually wiping them out. Is that not correct?
Yes, Your Honor.
So is this law for the purpose of wiping out the poor or helping them achieve a quality of life that Congress may have determined possible if this particular law was there?
It's really to uplift the quality of life of the poor. And it is not even anti-natalist, because the law provides that the poor is not deprived of having children because of economic reasons.
Thank you, Counsel.